the first to know. Nsem-Pii TV.
Ebetuja say Chief Justice Mahama get to Torkonoo ehodu a press conference. Na enrada enumere ana po adomochere nso ne lawyer Ejeba Afua etenase omtwe enkomo. Ana enra kwa na nso no breaking news na Sabetuja na say Chief Justice get to Torkonoo esan yeden Eddie Mahama ako ECOWAS court. Na eno enenam so ama po adomochere ene lawyer Afua omodi Nsem-Pii atudwa ene hawa enema bisi adane tisia no Justice Poorman ene wona after say suspending Mahama no ene committee ni nyina no kema kwakwa se omoto atwi na wuti analysis na lawyer Afua de ma na wutumu se ampa anhwa na enema adane sanse John Domani Mahama bekasa no ka se ono de why do be wi na se dia kana ka committee eno no kire se how enema be say na atten ko so no kema ko se na se onigidi do committee ni nyamfa omo you mo ye no ihwemu no mo ye no mo nyamfa eho anu ye nya de nyamaye enti no ye twen basisi an de court no Chief Justice get to Torkonoo ede Mahama akọ ECOWAS court. Mo menkukuti po adomochere message here.
For good evening, welcome to the studio.
Good evening, my brother.
You are coming from Parliament and coming from extensive practice of law. What do you make of the Chief Justice press conference? Should she have spoken?
It may appear that by speaking, she'll be breaching the provision of the Constitution regarding the secrecy of the process. That said, she appears to be in a very desperate situation. And when somebody is in a desperate situation, you know, they may want to explore avenues so that they can be given a hearing, or people come to their aid. She said so many things yesterday. What for me is at the core of, the core of the issue is there seems to be a breach or lack of procedural integrity in this matter. And I would want to say that regardless of what we think of her, she has a right to be heard, and she has a right to be deemed innocent until proven guilty. At the heart of our law, in terms of dispute resolution, is that everyone is innocent until proven guilty. And indeed, the law requires that when a person is going through processes of this nature, be it criminal, be it disciplinary, the person is entitled to all the assistance that that person requires to be able to prosecute his or her case ordinarily. That then means that the Chief Justice, like any other Ghanaian under the Constitution of this country, rather needs to be assisted to defend herself and not to be treated as a person who is guilty. You know, Paul, you said something that is really true. We don't develop a country, right, other than using principles and values. And so we need to build a country of principles. And through the principles, we'll develop the values of this country. You see, without the establishment of a prima facie case, this whole hearing wouldn't have taken place.
What is that?
When you look at Article 146, there's no need for the president to constitute a committee to inquire into the complaint until the president has established a prima facie case in respect of the complaint. In other words, the president deems it necessary for the Chief Justice to answer the complaint. And in answering the complaint, she answers the complaint before the committee. A committee of 2 justices of the Supreme Court and 3 persons who are neither lawyers, members of parliament, or council of state. And so that makes the prima facie determination very important.
Break it down a little bit. What does that? Prima facie means
Prima facie-
president looks at the petitions, looks at a response, and says, I'm not convinced. The committee must hear
The
you.
president, together with the council of state, say that, look, in respect of this petition, you have a case to answer. You should respond to this in a more detailed manner than you have responded in your comments. And so go to the committee and answer it. Paul, that makes it necessary, extremely important, for the president to inform the Chief Justice whether or not the prima facie was established in respect of all the complaints or parts of the complaint. From the Chief Justice's account yesterday, she doesn't know which part of the complaint that the prima facie case was established in respect of.
But she asked the committee.
Paul, she doesn't have to ask the committee. If you go to court, it's a quasi-judicial process. If you establish a prima facie, in setting up the committee, you have to put me on notice that of all the issues that were brought against you, we think that as for this one, you should answer them. Don't forget, under the Constitution of Ghana, if you are a judge, you have some immunity. Under Article 127, those immunities are provided to ensure that judges can do their work in freedom without fear or favor or ill will. So they are there to protect judges. Some of the complaints that have been brought against the Chief Justice, right, are in respect of his work sitting as a judge, president of the Supreme Court, right, in respect of some of the matters that she sat on. And so if you have established a prima facie case, is it in respect of the complaint that concerns her work as president of the court in specific matters that she sat on, or other matters which are totally unrelated to her work, her work as a judge, but administrative duties? But you have to make her aware. Let me tell you why it is important you have to make her aware. In coming to the committee, there is a burden of proof. You see, not all cases requires that the petitioner must prove. When an allegation, for instance, is made in the negative, the burden is rather not on the complainant, it's on the Chief Justice to prove. And so if you make allegations against the Chief Justice and the President has found it necessary to say that I've established that there's a prima facie, it is important for you to let the Chief Justice know which of the complaints you have established the prima facie. That makes the Chief Justice, that puts the Chief Justice on notice, makes the Chief Justice prepared, right, in coming to answer it. But the most bizarre thing, which for me is sad, is that whereas the Chief Justice has not been told which of the complaints a prima facie case has been established, some government communicators have spoken extensively on this matter in the media.
About the prima facie.
About the prima facie, taking the complaint, the petition, and stated that in respect of some of them, the President established prima facie. In respect of others, there was no prima facie. So if the person who is going through this process does not know, right, which of the complaints a prima facie case has been established, but government communicators know about it, is it fair? It is not fair. And so for me, in my humble opinion, right, it really undermines the integrity of the process. And it is very sad that the Chief Justice of the Republic of Ghana should be going through this. No matter
So without that, I thought that would guide the committee's work. Is that not what? So she goes and they say that there are 3 petitions against you. Petition number 1 is from Paul Adumochi. He says that you don't come to work early. And the President has seen the evidence of Paul Adumochi, has seen your response, and thinks that you should explain yourself to the committee. Without that, what process are they going through?
Paul, and that is what makes it bizarre. And so without further information, I am saying that what is happening undermines the integrity of the process. It casts the whole process in a certain light, right? That makes it seem not to be genuine. It appears that people are using the camera or the secrecy of the process to achieve a certain end without more. And that is why it is important for the issue that the Chief Justice has raised to be answered, particularly the absence of notice to the Chief Justice as to which part of the complaint or the petition a prima facie case has been established on. Without more, it really, really, really casts serious doubt on the integrity of the process. Look, I understand that the procedure which is being used or has been borrowed is the civil procedure rules.
Yeah.
And the Chief Justice thought that they should rather use the commission of the procedure, designed for commission of inquiries. I understand, I saw Mr. Tadiosori also, raising issues about the Chief Justice's position.
Yes.
As much as the committee is free, together with the parties, to agree as to the procedure to be used, right? I think that the commission of inquiry is analogous, and that for me should be preferable to the civil procedure rules, which is an adversarial regulation of our courts, adversarial regulation or procedure that regulates litigation in our courts, which is why the Chief Justice is saying that the whole process is very adversarial. My brother, even employer-employee relationship, right? Matters relating to employer-employee relationship. When there is a hearing, when you go, you are told exactly why you are there. You are told exactly why.
So she's not being told. That's why she's talking about Nebuchadnezzar?
Yes, because a petition has been filed. That petition, right? There are 3 petitions containing various complaints. Those 3 petitions, right? The president says he has established a prima facie case on. The duty was the president and the Council of State have established a prima facie case on. There is a duty, a legal duty, to inform the Chief Justice whether the prima facie case was in respect of all the 3 petitions or parts of the petitions.
So she will know how to prepare?
So she will know how to prepare. It's a basic principle.
So she's being tried in the dark?
She's been tried in the dark. She's been tried in the dark. It's the basic principle of the rules of natural justice. I have to know what I'm up against. It helps me in preparing my case. It helps me in knowing the burden on me in terms of the evidential burden. It helps me in putting together my evidence. It helps me, right? Paul, even in the Garden of Eden, when Adam, right, went to eat the apple and God appeared and they said, and he asked them, Adam, what have you done? He gave Adam the opportunity, right, to answer for himself. That's the rules of natural justice. You should put the person on notice, the nature of the case you have against that person, which is why in civil litigation you file pleadings. The pleadings comes to you, you have sufficient time to prepare your case. That is your defense. Okay? In criminal law, in recent times, in the case of Martin Pebu versus the Attorney General, the Supreme Court has held that disclose all the evidence you have against the other side, so that based on it, the person will prepare his or her case. Okay? I think that it was, that underpins, that philosophy underpins our justice administration system. It is to ensure fairness, so that nobody is ambushed. I mean, think about it. The Chief Justice is undergoing through this process in camera, where from her account, she's not even allowed family members or witnesses to come along. Even in employee-employer relationships, when you are going for disciplinary hearings, Paul, you are asked to bring a friend to witness what goes on. So why are we doing this? If the Chief Justice's account for me is true, without more, I think that the integrity of the process is significantly undermined by what we are saying, by what she has said. And something has to be done to remedy the situation. A lot of the things she said, for me, are sentimental, right? I think that the government can, in the spirit of fairness, address them. For instance, if it is Edu Lodge she's not comfortable with, government can assist by providing an alternative venue. I think, for instance, that in respect of those issues, the Chief Justice could simply have written to the government to express her concerns. And if they had not been addressed, then she could have stated them in her press conference. And so for me, the complaint in the press conference in respect of that, for me, could have been handled in a better way, differently. Yeah. But in respect of this matter, how many times haven't we talked about this prima facie and the need to give the Chief Justice notice of what constitutes the prima facie? President Akufo-Addo, when various complaints have been made against, petitions have been brought against previous Chief Justices, Chief Justice Georgina Wood, Chief Justice Sophia Kufu, Chief Justice Enini Ebua, in all instances, when he deemed that there was no prima facie case, did not just write to the petitioners and say that there is no prima facie case. Professor Kweku Azar, he had petitioned against the Chief Justice, and the president didn't just simply write to him and say there is no prima facie case. He gave reasons why there is no prima facie case. He went over and above himself.